Welcome everyone to the Vocational Science of Freedom online civics class. This class will run from 11 a.m. till 8 p.m. and the channel will be muted for an hour and a half, and then the last half an hour of the 2-hour session there'll be a Q&A. So without further ado, let's open up the outline for the class and get into the first section of the class, which is presumptions. And if you want to grab the outline, and then you'll see in the outline once you open it up that there will be the little entries in red will correspond with the document that has been posted in the room. So as we go down, there'll be, I believe there's 28 of them. So that's what I've posted for the whole day. To start with the outline, just to give a little example of what some of my outlines are and some of the rest of the docs that are in here. Most of my papers are color-coded, which a lot of you know. Red means pay attention, light blue text means pay more attention. Dark blue usually means categories of certain things. And then purple, which I also sometimes have in italics, purple is basically my own notes on a subject or my own opinion regarding some specific thing in the document. And I pretty much keep that uniform throughout all of my documents. So to begin, the first section of the class will be our status as one of the people and the presumptions that the Bar Association uses to destroy that status, and what you need to file onto the public record to correct any presumptions that exist to deny you that status. A list of some of these presumptions that are most used against you are listed below. Now, this is not an exhaustive list. However, the list that I did create, we will be going through extensively as to where these presumptions come from, why they're important to understand, how they're being used against you, and how to correct them. Now, these are in no particular order. They were listed out before that I had created a few years ago that I'd been kind of working on and expanding. So again, these are not in any particular order. However, the first one does seem to be probably the most important, which is A, that you have not been found to be living and are a decedent, and under the IRS code and in the IRS master file. This is a presumption used against you to make you dead to your own estate and under the common law and dead to the law in general. Now, let's open up the Certificate Act, a document that shows where this presumption has been used in the past. So we open up the Certificate Act of 1666. This was an act in English Parliament legislation pre our revolution. And this will show you in a way of what they were doing to steal the estates of the people of England. Now, you have to understand that the Certificate Act of 1666 came out right after they burned London to the ground. So you have a massive false flag, basically terrorist event, of which they burn everything to destroy all the records, and then they come out with this and they say, hey, if you can't prove that you've been found to be living or go through this paperwork, then the Crown is going to take everything that you own and administer your estate. So the most important section of the Certificate Act is actually down in section 4, but I'll read some of the other sections before. So recital, I'll just start at the top. An act for redress of inconveniences by want of proof of the decease of persons beyond the seas or absenting themselves without upon whose lives estates do depend. Some of this is going to be a little bit difficult to read because this language is kind of older, so you have different spellings of various different things. But anyway, so recital that Certificate Vice, and that's Certificate Vice is an aspect of someone who's a beneficiary of something. Certificate Vice is kind of like by what right do you live, sort of. So recital that Certificate Vice have gone beyond sea, and that revisioners cannot find out whether they are alive or dead. So they made it sound as though a bunch of people left beyond the seas and went off to some other place, when really what they did was they burned London to the ground. They said, well, okay, can't find you, we kept your stuff. So whereas diverse lords, manors, and others have granted estates by lease or for some or more life or lives, or else for years determinable upon one or more life or lives, and it hath often happened that such person or person for whose life or lives such estates have been granted. Now, this is an aspect of being granted, because you got to remember under the feudal system and the king, the king owns all the land. And so all of their land titles were always by grant in fee of some sort, fee for years, feudal fee. That's where you get the idea of feudalism from. So that have been granted, have gone beyond the seas, or so, that's just drop the E, so absented themselves for many years that the leaseors and revisionors cannot find out whether such person or persons be alive or dead by reason thereof. Such lessors and revisioners have been held out of possession of their tenements, meaning the capacity for someone to be a tenant, for many years after the lives upon which such estates depend are dead, in regard that the lessors and revisioners, when they have brought actions for recovery of their tenements, the places that they're renting out, have been put upon it to prove the death of their tenants. Meaning, okay, we don't know where this guy is. Can you prove that the tenant's dead to move the fee? Okay, that was what their situation was. And of course, all of this aspect of fee, which I'll get into later, all this aspect of fee and usufruct is the Roman civil law system coming in, that came into England in 1066 with William the Conqueror, with Roman civil law. Okay, so anyway, so that's the aspect of what they're doing here. I'm going to skip down to section 4. If the proposed dead man prove to be alive, then the title is revested. Okay, the title is revested. We have a title to our own estates. Now, the substantive definition of an estate is everything that a man or woman owns in law. So, the title to your own inheritance, everything that you own at law, when you're considered dead to the law, you have no right to own it. So this is an aspect of your life depending on your estate. Okay? So, section 4. If the supposed dead man proved to be alive, then the title is revested. Action. An action. That means an action at law. Because you do an action at law for mean profits. That mean word, that actually used to mean middle. That word mean, it meant middle lord. For the lords that have the middle profits of the leaseors or the tenants. Action for mean profits with interest. Provided always that if any person or persons shall be evicted out of any lands or tenements by virtue of this act, and afterwards if such person or persons upon whose life or lives such estate or estates depend shall return again from beyond the seas, meaning they came back to, they were found again. Doesn't necessarily mean that they were across the sea, but just that they were found. Or shall, on proof in any action. So on proof in any action. Okay, so you prove how? You prove you've been found to be living where? In any action. Okay, that's very important. You have to do it in an action. To be brought for recovery of the same. To be made appear to be living. To be made appear to be living, or to have been living at the time of the eviction, that then and from henceforth the tenant or lessee who was ousted of the same, his or their executors, important, administrators, right, so notice that executors and administrators are two entirely different things, or assigns, shall, may, that's something else I'll get into later, the difference between executors and administrators, we'll cover that later, or assigns, shall, or may re-enter, repossess, have, hold, and enjoy. That's a very important part there, okay? To have, hold, and enjoy. You'll see that clause in the original land patents of the lands of America. You'll see it. It's called the Addendum Clause. It's to basically to have, to hold, and enjoy for your life and for your heirs, basically. Okay, so you see this all the way back much older, in much older law. Okay, so anyway, shall, may, or re-enter, prepossess, and have, and hold, and enjoy the said lands or tenements in his or their former estate for and during the life or lives so long, that's term, just drop the E, as the said person or persons upon whose life or lives the said estate or estates depend, shall be living. So what that's basically saying is that you have the right to your lands and your estate as long as you're living, as long as you prove in an action, right, that you've been found to be living. Now what that's called is an inquest. It's called, usually it was done by coroners, and it was called a judicial inquest. So it's a judicial proof of life inquest. Now, this is one of the important docs that we've created at the Vocational Science of Freedom to get rid of this presumption. So that's one of the documents that we've done. And I'll get into the rest of the documents also, that when I go over these presumptions, I'll be talking about each and every one of the documents that gets rid of and rebuts that presumption. Okay, so to continue. So this is what they're doing. This is their presumption that you're dead. And that's how you get rid of the presumption. Okay? You prove in an action, in our case what we did was a proof of life inquest, because an inquest is an action, that your life depends on your own estate and that you have been found to be living. So to continue, and also shall upon action or actions to be brought by him or them against the leaseholders, revisioners, or tenants in possession, or other persons respectively, which since the time of the said eviction received the profits of the lands or tenements, recover for damages the full profits of the said lands. So all that, what that's saying is, it's saying, look, once you prove that you've been found to be living, you get to come back, claim your entire estate, and everybody that's ever made any money on leasing out what was yours, you get back. Okay? And it continues, respectively, with lawful interest. So, say for example, the county that's been basically the landlord and has been collecting property tax. What is that? That's them having tenants on your lands. That's what they owe you back. Because all of our lands in America are allodial, which is clearly written in, even specifically, in some of the state constitutions, namely Wisconsin, that says all lands in Wisconsin are allodial and feudal tenures are prohibited, as I recall. Should be the direct quote. And because of that, allodial lands are not taxable. You don't have a landlord. Okay, but that's what the counties have been doing. That's what the municipalities under Roman civil law have been doing. They've been using this aspect of perceiving that we're all dead and getting profits off of our estates and off of our lands. Okay, so that's basically the scenario of that. And then it ended up, so for lawful interest, for and from the time that he or they were outed of the said lands or tenements. See, lands or tenements. So lands is the fact that you're the lord, or tenements meaning that you're a tenant and you have right to be there by some lease. But we're focusing on having the allodial land title, okay, as Americans. And keep or held out of the same by the said leaseholders, revisioners, tenants, or other persons who, after the said eviction, received the profits of the said lands. So after they're receiving the profits, or any of them respectively, as well in the case when the said person or persons upon whose life or lives such estate or estate did depend, or shall be dead at the time of bringing of the said action or actions, as if the said person or persons were then living. So as long as you can prove that you've been living for the amount of time that they've been taking, then you get it back with interest. That's the point. Now, this is what they were doing in 1666 after they burned London to the ground so that they could keep everything. This is the filthy bar association trying to steal everything. So, the problem is that they've been doing it now in a different way here. But there's no remedy. We're never shown where this remedy is because they don't want us to have one. But I will teach you that there is one, and I will teach you the ways of how to have the remedy properly. So let's close up Sesvique Vayact, and let's move on to the aspect of the master file and what shows in the master file regarding access to an individual master file. And if you click on it, it'll give you some good background outlines of how to locate and get your individual master file from the IRS. Now, when you get your master file from the IRS, what you'll find is that you are labeled as a decedent. Why would they do that? It's so that they can administer your estate. So let's go into the outline and let's look at the definition of death. Now, this is all of the definitions that I have in the outline, and throughout the rest of the docs you'll see today all come from Bouvier's Law Dictionary, okay, which is the only dictionary that Americans should use as far as American jurisprudence by no less than 3 acts of Congress as well regarding anything of a constitutional nature. And because the dictionary itself is structured and created for American jurisprudence. So death. This is definition 8 of death. One is it is a general rule that persons who are proved to have been living will be presumed to be alive till the contrary is proved, and when the issue is upon the death of a person, the proof of the fact lies upon the party who asserts the death. Okay, so that's what ticks them off. If you walk into any court, I don't care what it's for, whether it's the traffic ticket or doesn't matter. Even if it's murder, doesn't matter, because all crimes are commercial. And you walk into the court and you say, Your Honor, I come before this court today as having been found to be living. They will have a serious, serious problem, because they can no longer see you as a res, R-E-S, meaning a thing, of your estate, or of the estate, which is the all capital letters name on the birth certificate. That is an estate. That's not a corporation. It's an estate, and I'll get into that later. But just as for now, when you walk into a court, your body is actually there as a res, a thing that's being administered because no one's claimed you. So once you say the contrary is proved, and you say, I come before this court as having been found to be living, you have just spoken law out of your living voice, and then they have to prove that you are dead the second that you do that. Okay? To continue here with the definition of death. But when a person has been absent for a long time, unheard from, the law will presume him to be dead. It has been adjudged or adjudicated that after 27 years in that particular case, 20 years in another case, 16 years in another case, 14 years in another case, 12 years, 7 years, and even 5 years, the presumption of death arises. Well, isn't that convenient for the attorneys? Okay, you don't show up or whatever. Maybe you just decided to leave your house and go on a vacation for 5 years. Maybe you decided to take an expedition to the Arctic or something. Or whatever, doesn't matter. Maybe you decided to sail around the world twice. So be it. What do they try to do? They try to come in and say, oh, he's dead, so let's steal his stuff, right? Typical modus operandi of them. So the point is that after 7 years, which is usually the aspect of American jurisprudence, usually 7, not 5, but anyway, 7's pretty much their norm. So when you get abandoned by document, with the mother and the father signing the birth certificate at the foundling hospital, and a foundling is a lost or abandoned child of unknown parentage. That's a foundling. All of the hospitals out here are foundling hospitals. Okay, all of them, and they're all run by the Knights Hospitallers. What are they doing? They're finding children because the mother and the father abandoned them at the hospital by contract. That's the birth certificate contract. Now it says right on the birth certificate contract, if you go and find any one of them, and it's difficult to just get a copy. You pretty much have to know a pregnant woman and then ask her to go get 2 copies of it. If you look at the top of it, it'll say, if you do not fill this form out, you will be fined $1,000, blah, 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 or whatever it is for each state. Well, that's instantaneously a contract under duress. Duress meaning you can't force someone to enter into a contract. And if you do, which would be, say, me holding a gun or a knife to someone's throat and saying, sign this. Is that a valid contract? The answer, of course, is no, it's not a valid contract. But that's what they're doing at the foundling hospitals. They're demanding that the mothers and fathers enter into these contracts so that they abandon the children by document. Okay? And if you notice on the birth certificate that it always says the mother's maiden name and the father's married name. So what does that end up looking like as far as documentation is concerned? It makes the child look like it's a bastard. And bastards under common law cannot inherit. So again, that's another presumption that we'll get into later. So from that standpoint, so you get abandoned there by document. And then no one corrects the record for 7 years. So you're presumed dead. That's why it's an all capital letters name on your birth certificate. Okay? because of the presumption of death, right? And it's also on bond paper because they have to bond your estate. The estate has to be bonded from the standpoint that if any damage, harm, loss, or injury comes to that estate, then the bond will cover it when the heir, you, properly comes forward and claims it, which is why there's a fidelity bond connected to every single birth certificate at Fidelity. There's a very large bond, millions of dollars, connected to your birth certificate sitting at Fidelity. And the reason they have to do that is because they are only special administrators. They are only being a special administrator for the time of which you have not come back and claimed your estate. So from the standpoint of the death thing, we can continue the definition now. It seems that even 7 years has been agreed as the time when death may, in general, be presumed. By the civil law, now this is an important aspect, whenever you see the word civil law, it always means Roman civil law. Okay, now Roman civil law is a foreign system of law to us. Always has been, always will be. By the civil law, if any woman marry again without certain intelligence of the death of her husband, how long soever otherwise her husband be absent from her, both she and he who married her shall be punished as adulterers. Now, I really doubt that there's any civil or ecclesiastical law anymore, that they haven't changed to get rid of that. But back in the days when Bouvier's was written, this was still in full force and effect. Okay, so that's your first presumption that they use, that you're dead. Okay, I explained to you how they did it, and I proved to you that that's how they see you. And all you have to do is go get your master file and you'll see it. Okay, that's the proof. So, on to the next one. So B, that you have not come of full age and are seen as an infant, as per 1 USC 8 under the definition. That's your United States Code. So, Title 1, United States Code, subsection 8, under the definition of person. And therefore are not able to handle your own affairs. And if you like, you can click on the link right there to the Cornell site to look up 1 United States Code, subsection 8, which reads, A, in determining the meaning of any act of Congress or of any ruling, that means any ruling of any court, federal, regulation, which is all the regulations of all the codes of the federal government, or interpretation of the various administrative bureaus, meaning anything that they've created since 1933 as far as an administrative bureau is concerned, and agencies of the United States, which is pretty much everything. That first part of that sentence includes everything in the federal government. The words person, human being, child, and individual shall include. Now, I have to pause here for a moment. The term shall include, the term include, when you use the word include in statutory construction or code construction, which is what this is, when you use the word include, it does not mean and also. What it means is that when you use the word include, whatever you state after that word means this and nothing else. So if I were to, say, write a statute that said, trees include oaks and elms, a pine tree would therefore not be considered a tree under that statute. Okay, that's how that works. So, and the word shall is absolute. May and must are the same. May means the same as must, and must means the same as may, but shall is absolute. Okay, there's no deviation from it. So these words, person, human being, child, and individual, shall include every infant member of the species Homo sapiens. Every infant member. You're an infant. A person is an infant. That's what they're doing. They're administering the estates of infants. Nothing more, nothing less. That's what they're doing. That gives them their second presumption, or the second presumption on my list. As I said, these are not in any particular order. Okay, but these two are two of the most important. Now, once the presumption of infancy is rebutted, they, the ones that are administering the Bar Association, are now required to give you your estate as per Articles 3, 4, and 5 of the Magna Carta, without fine and without fee. Now, let's Go down to the Magna Carta, open up the Magna Carta. Scroll down to Article 3, 4, and 5. Just to give a little background on the Magna Carta for anybody that may not know. The Magna Carta was written in 1215 AD by King John. And what the barons did was they basically cornered King John, who was the descendant of the filthy William the Conqueror. And the barons, the landowners, had basically had enough of this idiocy for 200 some years. And they said enough's enough. And they said, we're going to now take back what's ours. And they forced King John to sign the Magna Carta. Now, of course, the Pope said, well, that was a contract signed under duress. Okay, granted, I'll give him that argument. But every single king after King John, from a standpoint that it was the basis, it's called the Great Charter for a reason. It creates and forces all monarchy to realize that they're not all powerful, and that the other members of the peerage, meaning the other members of the sovereignty, the barons, as we are in America, we're all sovereign as well, as one of the people, have, when we wish to, collect our power and wield it above the king. So that's the little background of the Magna Carta. I'll just leave it at that for now. So when we get into the Magna Carta, what we find here is that the barons were having the exact same problem with King John back then as we're still having today. These people continue and continue and continue to do the same thing. Now, why? Why does the filth of Rome continue to do this to all of the world? Well, because it worked so well from them back in the days when Nero, with the agreement of the Senate, burned Rome to the ground and brought in the 12 tables, which is very much like the Sesquivae Act from a standpoint that says, if you don't have proof of who you are and your record of having these things, guess who gets them? Caesar. Well, how convenient, okay? Because the Romans were really only good at two things, keeping records and keeping slaves. It's all the empire was ever built on. They stole everything else. All of it. There was no great masters. There were no intelligent men of Rome. They were all morons, all of them. And all they did was steal everything from all other places. But I digress. Let's get back to the Magna Carta. So, from the standpoint of the presumption here about being an infant, okay? Article 3 states, but if the heir of any of the above persons, which was the barons and the members of the peerage, shall be under age and in wardship when he comes of age, and some translations of Magna Carta say when he comes of full age, he shall have his inheritance without relief and without fine. Okay, what does that mean? It means when you're competent to handle your own affairs, because when you come of full age, there's no specific number of years. It's when you can handle your own affairs. Okay? So when you come of full age, you shall have as your inheritance without relief and without fine. What does that mean? You can't fine and fee me for the use of my own property, of my own estate, meaning my own body, and also my allodial land, if indeed you have title to such thing. So number 4 says, the administrator of the land of such heir, who shall be under age, shall take none but reasonable issues from the land of the heir, and reasonable customs and services. Well, over the hundreds and hundreds of years of the Filthy Bar Association and the Templars, which is what the Bar Association is, they've come to the conclusion that 30% is reasonable. I tend to disagree. But anyway. And this without destruction of waste and waste of men or goods. Okay. Interesting point to be made here. Why is it that America has one of the highest per capita prison populations in the world, but has some of the nicest prisons? Ever wonder? It's because they cannot waste the men or goods of which they are administering, in case one of you grows up and shows up and claims, as a proper heir, who has been found to be living and who has come of full age, all of your estate. They have to keep it in good order, okay? So, to continue, and if we shall have committed the custody of any such land to the sheriff or any other man who ought to be responsible to us for the issues of it, and he cause destruction or waste to what is in his charge, we will fine him, and the land shall be handed over to 2 lawful and discreet men of that fee, who shall answer to us. That's where you get the transferring of, oh, he didn't pay me my property tax, so it's going to get handed over to 2 other lawful and discreet men of that fee. Well, what that means is the attorney and the judge gets handed over and gets handed over and gets handed over and gets handed over. That's what you have here. You have this flow of them stealing everything through these corporate courts from the aspect that they're all just special administrators. So they have to give it back. And to him or to whom we shall have referred them regarding those issues. And if we shall have given or sold to anyone the custody of any such land, and he shall have caused destruction or waste to it, he shall lose that custody, and it shall be given to 2 lawful and discreet men of that fee, who likewise shall answer to us, and has been explained, so on and so forth. Okay, so that's just how they're talking about transferring it. Well, when you claim your own lands, allodial, and declare them to be allodial, and you've claimed your own estate and claimed your own body, as an American, being sovereign, member of the peerage, you take everything back, and there's nothing more they can administer. No Roman civil law can touch you after that unless you're ignorant enough and stupid enough to enter into a contract with the corporate state again, whether that be anything from Social Security to submitting an application for registration. The most important word in that sentence being submit, of anything of your property, to register it. Because when you register something with the corporate state, you're saying to Caesar, here, protect me. I'm going to give you the title, Caesar, and you're going to allow me to use it under the rules and regulations which I have allowed you to put over top of me, basically. That's the problem. It's the problem with the vast majority of the system, including but not limited to the children as well, which is also takes effect with the children. Okay, so let's move on to number 5 here, clause 5. The administrator, moreover, so long as he may have the custody of the land, shall keep in order from the issues of that land the houses, parks, warrens, lakes, mills, and other things pertaining to it. And he shall restore to who? The heir, when he comes to full age, his whole land stocked with plows and wainages. Wainages was an aspect of waxing and waning of the moon regarding planting seasons. According as the time of the wainage, again, dealing with the moon, requires for planting or harvesting, and the issues of that land will reasonably permit. Okay? So in Article 3, 4, and 5 of the Magna Carta, you see that the barons made sure that they wrote this down to say, enough is enough. You're not going to keep our land. We shall keep our land. And these are the means and methods of which we shall make sure that the heirs that have come of full age get to have title of that land and of their own estates. Okay, so that's the aspect of infancy and coming of full age, and showing you how far this goes back, all the way back to 1215 AD, which is when the Magna Carta was written. So, now, to get rid of this presumption, what we have in the Vocational Science of Freedom goes right along with the one that gets rid of the death presumption. When you do the judicial coroner proof of life and proof of age inquest, it covers both of these presumptions. Okay, so what you have is someone of the medical field, and it's anyone who has a medical license. It can be a registered nurse, it can be paramedic, it can be technically, I mean, you could even have a veterinarian do it if you wanted to, because all I have to do is prove that you've come of full age, can handle your affairs, and that they prove some sort of aspect of life, whether it be caloric intake, blood pressure, all that, heat even is the proof of life. And you can have chiropractors do it. You can also have your family doctor do it if they're willing and they're knowledgeable in law. I suppose technically you could even from a certain aspect, there really wouldn't be any problem with even having a dentist do it, because he's still a doctor, still a medical doctor of a type and in the medical field. So basically anyone who's capable of taking a reading and has, and we make sure that it's somebody that has a medical license, just to basically throw it back in the face of the state to say, look, here's the license that you prescribe to allow this man or woman to determine these facts. And so therefore there really isn't any way to get out of it. Eventually, of course, none of us should have to have licenses of all of the professions that I just mentioned, and any other for that matter, in order to make a living. But for now, that's how we take care of that. And then after you've appointed your judicial coroner, they convene a petite jury of 12 men and women that then agree to the facts in the judicial proof of life and proof of age inquest that then you're now appointed judicial coroner of your own house then signs off on. Now, because an inquest is a matter of life and limb, there's another part of the Magna Carta which states something regarding matters of life and limb. And let me see if I can find it here really quick. Yeah, okay. Yeah, it's number 36. It's Article 36. So let me scroll down and read it really quick. And this is the part of the reason why we can do what we do as far as the status docs at the Vocational Science of Freedom. So, Article 36. Henceforth, nothing shall be given or taken for a writ of inquest in a matter concerning life or limb. Meaning you can't charge me for doing this. Okay? But it shall be conceded gratis and shall not be denied. So, what is a proof of life and proof of age inquest? Is there any defendant? No. There's no one coming against you and saying, well, you're dead. No. It's an inquest done as a matter of record. It's a matter concerning life and limb. So it shall be conceded gratis and it shall not be denied. So everything that we're doing has total basis in law, that it cannot be altered and cannot be denied. So that's why we did it the way we did it. So once we correct the public record, that gets filed into the county recorder's office, and then you get your county recorder number on the top of it, and then you can use that document forever to always prove to any court that you've been found to be living. Okay. So let's move on to number C here. Presumption that you were not born of parents that were in wedlock when you were born, and therefore you are a bastard, and therefore are unable to inherit under the common law. So if we go up to and look at the definition of the word bastard, a word derived from bas or bast, signifying abject, low, base, and arid nature. A child of low birth, according to Blackstone. A bastard in the law, in the sense of the word, is a person not only begotten but born out of lawful matrimony. So that's the point. That's what they do with the birth certificate. They make sure that the mother's maiden name and the father's married name, the last names are different. Okay, that's what they make sure of on the birth certificate, so that it, by documentation, appears on the record that the child is a bastard, that we're all bastards. Okay, that keeps you, in doing so, in doing that one simple thing, what they are doing is they are removing your capacity of being a member of the posterity spoken of in all of the preambles of all the constitutions. So they instantaneously, by that one presumption, have revoked every single protection under the state or federal constitutions that you think you have. They're gone. Right then, right there. So it's extremely important to understand what they're doing and to rebut and fix all of these presumptions on the public record. It's the only way you do it. So, to continue, this definition does not appear to be complete inasmuch as it does not embrace the case of a person who is the issue of an illicit connection during the covenanture of his mother. The common law, says the mirror, only taketh him to be a son whom the marriage proveth to be so. Okay, so again, this is an aspect of the common law that you cannot inherit unless you were born in wedlock. Okay, I'm not going to read the rest of this. You guys can read the rest of it. That was the main part of it. The aspect of, okay, that that a bastard cannot inherit. Okay, that's the point. So, from the standpoint of the bastards, what they're doing is the bastards can acquire the rights of legitimate children only by an act of the legislature. Well, isn't that interesting? Now, that's Black Law Commentaries. Whenever you see BL, that's Blackstone's. So Blackstone's Commentaries, first Blackstone's page 460, because Blackstone's comes in several different segments. So it says that they can require the rights of legitimate children only by an act of the legislature. Well, isn't that nice? Well, nope. What we're going to do is we're going to say, look, I'm not a bastard. Thank you very much. Okay. How do you fix that one? What we've stated in the status docs is that every single beginning line in the status docs of how we begin them in the first paragraph is stating who we are. We say that we are the son or the daughter of a legitimate son or daughter of married parents. So we state it as a fact. Now, once you've stated something as a fact, and this goes for any court or any public record, doesn't matter what it is. Once you accuse yourself of being something, it's then upon the other side to prove that you're not. And of course, within reason, because you say, okay, I'm a pink elephant. Well, yeah, that's different. But within reason, from a standpoint of declaring something to be truthful as far as facts are concerned and lawful. That fact, of course, being both. So that's how we take care of it in the status docs, the bastard part. Some people have gone to the extent, I've never done this or known anybody personally to do this, but some people have said that they've gone to the extent of correcting the birth certificate. Well, you got to remember that there's two different types of certificates. There's a certificate of live birth, which is on a white document, not on bond paper, which is at, I believe, the Office of Vital Statistics of each state. And then there is the birth certificate, which is on bond paper, usually blue or something, that is a security and takes its information from the certificate of live birth and then bonds it as you basically now having been abandoned and considered dead. So I've heard of people correcting the birth certificate and saying, oh, I was born a married parent, so on and so forth. I don't see the point or the necessity of having to correct that specific record. What we do is we simply just do it in all of the status docs and say, look, this is what we are. So just to simply rebut the presumption under pains and penalty of perjury, and also specifically it's done in the proof of life and proof of age inquest. So you have not only a judicial coroner but also a petite jury signing off on the fact. So that's how we take care of the bastard problem. Okay, so let's move on to D here. That you are not the sole lawfully appointed general, absolute, rightful executor, and you can look up all those specific words: sole, lawfully, general, absolute, and rightful. Those are all specific terms regarding an aspect of what you can put before a specific office. And the office of executor of your own estate. Now, the estate is the all capital letters name, John Henry Doe or whatnot, that they charge under the statute merchant in these private for-profit courts. It is not a corporation. It never has been a corporation. It is a fiction of law. And some of the property of the said estate can sometimes be placed into a trust with other names, like John H. Doe, all caps, okay? Like it is on most people's Social Security card, okay? And how you'll see it printed in most court cases. It'll usually be first, middle initial, last. That's a constructive trust, okay? That's two different fictions of law. One's the estate, one's a constructive trust. Okay, but the all caps name on your birth certificate is the name of an estate, not a corporation, because there's no stock involved, there's no charter, so these people that got their heads screwed on wrong going around out in the community saying, oh, it's a corporation. No, it's not. It's not a corporation. Never has been. It's an estate. And you can prove the fact that it's an estate by two things. One, getting into the IRS forms, which we'll get into in a second. But two, I mean, the main thing about it is that there's nothing else that it could be. Okay, now some people have said, yeah, it's a trust, but the name of the separate name of the trust is different. You can't have a trust without an estate first. That's the point. It's impossible. So the estate had to exist first. Then you can take various different aspects of the estate, or various different res, R-E-S, a thing, from the estate and place those different things, the res, into different trusts. That you can do. And then you can have multiple different trusts. It's fine. Whatever. You can do that. But you have to have an estate first. Okay. So let's get into the aspect of the differences between executor and administrator. Okay. So let's go over administrator first. So let's pull up administrator. And let's take a look at that. Again, all these definitions are from Bouvier's Law Dictionary. So, administrator. Trusts. Right there. Tells you what part of law it is. It's trust law. Okay. An administrator is a person lawfully appointed, with his assent by an officer having jurisdiction, meaning some court officer, to manage and settle the estate of a deceased person who has left no executor, or one who is for the time incompetent or unable to act. What do these filthy courts do to you every single time that you start to stand upon your rights? They say, let's have a fitness hearing. Let's call him crazy. Let's call him incompetent. Okay, why do they do that? They do it because they want to make sure that you're not able to handle your own affairs. If you don't act properly in a court, as far as coming for, because all these courts are running probate at the same time. They're running multiple different jurisdictions all at the same time. But the most important jurisdiction that they're running in every single court is probate. All they're doing is having a black robe priest of El sitting up on the bench, which in Latin means bank. So you have a priest of El ruling for the bank, administering in an aspect of a trust the res, your body, of the estate, because you are incompetent or unable to handle your own affairs. Now, after you come before the court and you say, Your Honor, I come before the court as having been found to be living and as having come of full age. If you do not also say that you are competent to handle your own affairs, they will instantaneously, right then and there, the court itself, the judge, will say, the court comes upon its own motion to competency hearing, because they have to go after the next presumption to keep you under your stupid little cage, to keep your leash on. The thing that they absolutely fear the most is that some of us will absolutely get some of our leashes completely off, and that we'll have, at law, all of our rights. That's what they are desperately afraid of. And they'll do everything they can possibly do to not let that happen in court. But we can teach you how to completely reverse that, which is the vast majority of what this course today is about these presumptions and understanding what they are so that you can say the proper thing. Okay. So let's go on to the definition. I'll read some more of these. I'm not going to go through all the definitions of administrator, but I'll skirt over some of this. It will be proper to consider first his rights, secondly his duties, thirdly the number of administrators and their joint and several powers, fourthly the several kinds of administrators, of which there are many. By the grant of letters, so you do something by a letter, so a letter, letters administrator or letters executor, which is what we'll be getting in the form. See, because there's different types of probate. There's informal probate, which is what they're doing in all of these courts, which is where the attorneys come in and administer and do whatever they want to. And by attorney work product doctrine, they never actually put anything on the record because they don't have to, because they're just administering your stuff. And then there's formal probate. Formal probate is where everything has to be on the record and you have to prove everything, and you're basically settling the entire gross estate, which is what we need to do. Our entire goal is to settle the entire gross estate. You're supposed to be on land, but be able to walk, stand up, and do your stuff, and not be incompetent or unable to act like a fish out of water. Okay. So By the grant of letters of administration, the administrator is vested with full and ample power, unless restrained by some special administration. Wonder what that would be. To take possession of all the personal estate of the deceased, and to, what? Sell it. To collect the debts due to him, and to represent him. Huh? What do attorneys do? They represent you. The judge will say, so I see you have no representation in court today. Interesting fact. Yeah, well, if they ask you that, say, Your Honor, I do not need to be represented. I am present. I present myself in my case to this court, Your Honor. And I do not consent to any unlawful administration of any kind without my signed and sealed authorization. Basically, what you just told him is to go to hell. Okay, so he is authorized to pay the debts. This is the administrator. He is authorized to pay the debts of the intestate, that's the estate with no will, in the order directed by law, and in the United States, he is generally entitled to a just compensation. Well, that's why the attorneys take 30%, which is allowed him as commissions on the amount which passes through his hands. He is bound to use due diligence in the management of the estate, and he is generally on his appointment required to give security that he will do so. Why are all of the cases that you go to in these for-profit courts bonded? Because they have to give security. If there's no bond, they don't have a case, which we'll get into later. We'll get into how to absolutely 100% destroy the bonds for any court case. You nullify the bond, you terminate the bond, there is no more case, period. And we'll teach you how to do that later today, okay? So, he is responsible for any waste which may happen for his default. That's the attorney. The attorney he's responsible. And if you put it on the judge, so's the judge. That's why they get a little bit leery about when you do things like cancel bonds and come in there as the executor and say, hey, I'm the sole lawful heir. Is there any objection to what I just stated? And there's, of course, never any objection. And you say, Your Honor, for the record now reveals that the sole lawful executor and heir has been found to be living, has come of full age, and is competent to handle his own affairs. And he demands his full entire estate now, with full accounting. You have that, don't you, Your Honor? And guess what? They do. It's in that little green or black, whatever color it is, book or folder that the judge is looking at. It's in there. They have to have it. They have to have it ready for you. Okay? Now, there was a man one time who found, kind of by happenstance, the little roller things that they keep all the cases in, that they roll into the courtrooms, a couple hours or half an hour before court starts, whatnot, for traffic cases, whatever. That the clerk will then go down and pick up the stuff and then give it to the judge, right? Well, someone was walking through a courtroom one day and found the little Rolodex thing sitting in the middle of the hallway. And so he thought, how interesting. And then opened it up and said, well, looky here. Here's my court case. And what he found in it was the fact that the bonds are there. And what he did was he took pictures of the bonds. And he proved the fact that there was a bond. And he said, hey, look, I'm going to go cancel this bond. So he took pictures of it, got the bonding company's name, number, and everything else. And then he went and called the bonding company after he had his little court hearing. And he said, yeah, I'm so-and-so. I'd like to cancel this bond. And they said, okay, well, just prove us, just send us some ID. He said, okay. The facts be okay? Sure. And he canceled the bond. And then he told the district attorney, basically, I think he sent him a letter. And then the next time he went into court, he said, Your Honor, I've canceled the bond on this case. And the judge turned to the district attorney and said, is that true? And the district attorney said, well, yeah, Your Honor, he gave me some sort of notice that he did that. And the judge slammed down the gavel. He said, case dismissed. He said, counsel, get into my chambers now. What was that attorney going to have to do? The attorney was going to have to write out a check to the judge, because every single filthy attorney has to bring their checkbook to court. Why? In case something like that happens. That's the reason. That's the reason why there are billions upon billions upon billions of bonds going through these private court cases. So from the standpoint of that, that's what they're doing. So they have to bond the cases to be the administrators, okay, to be special administrators. Now, if you come in there as the executor, that's different. Let's get over the rest of the administrator aspect, and then we'll get into what an executor is, okay? So number 4 here. He is bound to use due diligence in the management of the estate. He is generally on his appointment required to give security that he will do so. Again, that's why they have to give the bonds. He is responsible for any waste which may happen for his default. Okay, so I'm going to skip down to 9 here. Special administrators. All right, let's do 8, okay? Or no, okay, 7. As administrators are general, or those who have a right to administer the whole estate of the intestate, or special, that is, those who administer it in part or for a limited time. All of the judges are special administrators. They're all only acting as special administrators. That's it. Because it's what? For a limited time. That's how they set it up. That's how they set up the constructive trust. They put everything into the court case in a constructive trust, and then they're a special administrator for a limited time that administrates your estate property. So you have general and special. Okay, so get that. So general administrators are of 2 kinds. So you got, namely, first, when the grant of administration is unlimited and the administrator is required to administer the whole estate under the intestate laws. That's the general. Secondly, when the grant is made with an annexation of the will, which is the guide to the administrator or administer and distribute the estate. This latter administration is granted when the deceased has made a will, and either he has not appointed an executor, or having appointed one, he refuses to serve, or dies, or is incompetent to act. Again, because notice that the whole aspect of it is that the executor is always over the administrator. Always. Okay? That's the point. And then special administrators are of 2 kinds, limited for the estate and limited. I won't get into all that, so that's no big deal. So that's basically, and then the last part, I just want to make sure that you know that when you're using the word as a female, it's administratrix. So that's the female side of it. So just like you have paterfamilias, which is male, and materfamilias, which is female, which is the head of the household. So it's administrator. So now let's go into executor. The word executor, taken in its largest sense, has several exceptions. Executor dativis, who is one called an administrator to an intestate, executor testamentarius, or one who appointed to the office by the last will of the testator. And this is what is usually meant by the term. So what we have as far as the Vocational Science of Freedom status docs is we have a document that is your executor appointment, or it's female side, executrix appointment. So we appoint ourselves by will, we appoint ourselves the executor of our own estate by will, so that no special administrator can come in over the top of us and administer any part of our estate. You file that onto public record, get your public record number of the document, get a certified copy of it, file that into your court case. So then when you walk into court, not only are you verbally stating it, but you also have a public record, which is the highest form of evidence. Okay. So in the civil law, it's Roman civil law, the person who is appointed to perform the duties of an executor as to goods is called ares testamentarius. That's what we call ourselves also in many of the docs. Ares, sus are the 3 terms of which you wish to be. So those are the terms of which you are over your estate. Okay, so the term executor, it is said, is a barbarism unknown to that law. So executor, the term executor, is unknown to what law? The civil law. So the second that you walk in and say that you're an executor, that completely throws a monkey wrench into their whole entire civil law system. Now you're the lawful executor. Okay. So number 3, an executor, as the term is at present accepted, is the person to whom the execution of the last will and testament of personal estate is, by the testator's appointment, confined, and who has accepted the same. So you obviously accept your own executor appointment. And the only reason we're doing the executor appointment is not clearly because you're dead or because we're dead, but we're doing it simply as a stopgap to say, look, you're going to run all this stuff through probate? Okay, fine. Who's going to be the biggest in the room here? Well, it's going to be the executor or the executrix. That stops them from moving forward. If they wish to continue to move forward and they wish to continue to try to act as somebody, you can turn around and appoint them as a trustee, which is the lowest position as far as probate and trusts are concerned, which you have the power to do under the Power of Appointment Act of 1951, which I'll get into later. So to continue with an executor. An executor, as the term is presented, accepted is the person to whom the execution of the last one testament of personal estate is. Okay, so you accept the executor appointment. So generally speaking, all persons who are capable of making wills may be executors, and some others besides, as infants and married women. So technically, an infant could be an executor, but we get rid of that problem, pretense anyway. So an executor is absolute or qualified. So this is where you get into some of these terms, okay, where I was talking about that you're the absolute executor. So his appointment is absolute when he is constituted certainly immediately and without restriction in regard to the testator's effects or limitation in point of time. So, no time limit, no limit on ability, all the stuff. That's an absolute executor. It may be qualified by limitation as to the time or place wherein or the subject matters whereon the office is to be exercised, or the creation of the office may be conditional. It may be qualified. Okay, so you got absolute and you got qualified. By limitations in point of time, for the time may be limited, and of course also then the aspect of the stuff that they can administer, that they can control may also be limited. So that's basically all the rest of this says. I'm not going to get into the rest of it. The rest of that, I'm going to skip down to 9. The executor should prove the will in the proper office. All of the status docs of the Vocational Science of Freedom are all a continuation of your will. All of the docs say that they are a continuation of your will. So they're all lawfully can be placed into probate. Okay, that's why we did that. He shall make an inventory of the goods of the intestate, which should be filed in the office. That's when you get letters executor. When we get letters executor from the formal probate court, you'll be able to wander into everywhere, not just certain places, but everywhere, and say, oh, you have something in the name of the estate here. Well, I'm the sole lawful executor of this estate. I demand you produce a full accounting for me of this account, whatever it may be, whether it be the fidelity bond sitting at Fidelity, whether it be your allodial land title sitting at the county, whether it be any other aspect of any part of the estate that's sitting with the state treasurer. Wherever it is, doesn't matter. Once you have that, you can walk into anywhere and say, give me. Okay? Because that's your duty. It's not just a capacity. It's your duty to do that. You have to go and collect everything. If you fail to do so, they can say that you've failed to act, and they can say, well, you're obviously incompetent to handle your own affairs. That's not a position you ever want to be in. So what you want to do is get everything done and make sure that you have it all your ducks in a row before you start this, okay? So number 11, he should ascertain the debts and credits of the estate and endeavor to collect all claims with as little delay as possible, consistently with the interests of the estate, right? So get all your stuff. So that's the point. Our noble goal is to have a full accounting and livery, meaning to give to and to have and hold, to have a full livery and to sue out our livery as they used to do in the Court of Wards and Liveries, which I'll get into later. That's an aspect of an English court wherein when the heir had come of full age, as we saw in the Magna Carta, they had a specific court that they used to come into to suing out your estate or suing out your livery. And what you had to do was you had to sue your guardian. So it took me a while to find who the guardians were in our little unique American problem here. For a long time, I thought it was the corporate state. I thought it was the United States Federal Corporation. Turns out that's incorrect. I found it by scouring through 1,564 codes in the District of Columbia Municipal Act. All of which, by the way, had the word estate in them, which is how I eventually found it. And what it said in the DC code was that the guardians were trust companies. I thought, how convenient. Makes perfect sense. What's the biggest trust company in the world? Anybody know? The DTCC, the Depository Trust Company and Clearinghouse. And that's located at, I believe, 55 Water Street, which above the door they call the Tower of Power. And it has somewhere upwards of $46 trillion in assets. What do you think they're holding? All of our states. And eventually the hammer is going to fall on them when we start going to them, because that to me personally is worth a trip to New York, to walk in and say, hi, I'm general executive of this estate. I demand all accounting of this estate, everything that has this name on it, bring it forward. And they'd have to. And once you sue the trust companies, the guardians, for livery, in fact, I don't even think it's probably not even going to be necessary to sue them, but I'm fully prepared if necessary to do that, because all we need to do is pull an example from the Court of Wards and Liveries between, I think it ran from 1540 to 1662, I think. All we need to do is pull an example of how to sue out one's livery from that court, and then we'll have our remedy. Right? It wouldn't be any different, because remember, it'd still be a matter of life and limb, and remember, it'd still be considered gratis, so there wouldn't be anything anybody could do about it anyway. And then we just put it through formal probate. So to get back to the aspect of the executor administrator, just remember that the reason why we appoint ourselves as executor, or executrix as females concerned, is simply, again, just a simple stopgap. Okay, so it's just a temporary stopgap to stop the special administrators who are not appointed by our will or anyone's will and are operating in the aspect of administration of one's estate property through informal probate, where they aren't really bound by much of anything. With that, as far as the executor is concerned, there's more aspects of executors in here: general, special, so on and so, instituted. I'm not going to go through all the rest of these, but you're welcome to read them. I will read 25, however, because this is an interesting aspect of what they're doing. So 25 is an executor de son tort, or of his own wrong. So executor, de means of or from, son, own, and then tort is wrong. So executor of one's own wrong is one who, without lawful authority, undertakes to act as executor of a person deceased. To make, that should say, I believe, to make one, because there's some typos in here, but anyway, to make one executor de son tort, the act of a party must be 1, unlawful, 2, by asserting ownership as taking goods or canceling a bond. So, can they cancel a bond? No, they can't. Only you can. Okay? It's interesting to remember here. Make a point of that. And not committing a mere trespass, which they do all the time. An act done before probate of will, or granting letters of administration. One may be executor de son tort when acting under a forged will, which has been set aside. An executor de son tort, the law on this head seems to have been borrowed from the civil law doctrine of prohedeo gestio. He is in general held responsible for all his acts when he does anything which might prejudice the estate, and receives no advantage whatsoever in consequence of his assuming the office. So guess what? That's why they get so afraid when you come in your proper capacity. From the standpoint of when they come in, they know what they're doing. They know that they're acting executor de son tort. They know that they have no authority to do what they're doing, particularly when you come in and properly put your foot down. So that scares the crap out of them, because they can be prosecuted for it. So the question in text, I'm going to go back up to 2, because we had a question regarding the word barbarism. So whenever you see the word, when it's talking about a barbarism in any law dictionary or any legalese anywhere, okay, so when you say it is a barbarism unknown to that law, so I'll read this whole thing so you get the whole context of it. So number 2, in the civil law, that's Roman civil law, the person who is appointed to perform the duties of an executor as to goods is called ares testamentarius. Okay, semicolon. The term executor, it is said, is a barbarism unknown to that law, unknown to the civil law. It's a barbarism, meaning it's a word. Barbarism is a word and it's a derogatory term, but it basically means that it's something that some other foreign language says or some other foreign language does that's unknown to this language. It's a derogatory term from the standpoint that how did they speak? Well, they said bar, 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 that they didn't understand what they were saying. That's literally where it comes from. That's not a joke. That's actually where the word comes from. And so when you say an aspect is, it is a barbarism unknown to that law, meaning that what this definition means, number 2, means that the term executor is unknown under Roman civil law. The term executor is only a term of common law. Okay? It's a common law term. It's not a Roman civil law term. That's what it means. Did that answer your question? Okay, great. So with that, I'm going to get back to the outline, get back to looking at the outline. So we covered executor versus administrator. And so we'll pause right here and we'll open it up until 1 o'clock for Q&A. And then at 1 o'clock, we'll take a 10-minute break. And then we'll start back at 1:10. And I'll start back here by going through and explaining and showing the proof of how the estate's being administered through the IRS. So let me open up the server again. So if nobody has any questions regarding anything that I stated as of yet. So okay, let's take a 10-minute break and let's start back at 12:50 then.